you can go ahead and get started.
Okay, perfect. So I'm going to be talking about top compliance issues affecting Canadian registered charities. Just a little bit of background in terms of our firm. We're a firm in Toronto with 9 lawyers, and 5 of them just work in the nonprofit and charity area. We have a couple of blogs with extensive amounts of information on these types of issues at CanadianCharityLaw.ca and GlobalPhilanthropy.ca. And if you want to get a monthly email from us with recent updates, you can subscribe on either of the sites. And if you want to follow me on Twitter, I'm at Canadian Charity. So just some introductory points that this is legal information, not legal advice. The views expressed are my own. We will take questions at the end, and we'll go for about an hour and then take questions. So a couple of basic points just before we jump into the top 20 compliance issues. Essentially, registered charities are regulated by the Charities Directorate of the Canada Revenue Agency, which is a small part of this bigger Canada Revenue Agency. And these registered charities fall under both federal and provincial jurisdiction. So it means that there can be provincial rules that affect the operation of a charity in a province, and there are also going to be federal rules, and obviously the Charities Directorate is dealing mainly with the federal rules. Nonprofits and charities are both tax exempt. However, the big difference between a nonprofit and a registered charity is the ability to issue an official donation receipt, and that obviously comes with huge income tax savings for the donor. And as we will be pointing out, obviously there are benefits of being a registered charity, and there are restrictions on being a registered charity. Now, without going into any great detail, just want to point out that there are a huge variety of charities out there. And so, in other words, the right answer for one group may not be the right answer for another group. If your objects are different, it could constrain the activities that you can conduct. The areas of charitable work, if you're a hospital, there may be extra regulation, or if you're a daycare, there could be a provincial regulation that governs how you run the daycare. This presentation is going to focus mainly on high-level things that affect just about all charities, but just keep in mind that all of these different things make a huge difference as to what the right answer is. If you're an independent organization versus an affiliated one, there can be all sorts of rules and affiliation agreements and other things that tell you what you can and cannot do. And then another thing is that about half the charities in Canada have revenue under $100,000, and we have about 16 charities in Canada that have revenue over $1 billion. So there's huge differences in terms of resources. So also the right answer for one group in some cases is not going to be the right answer for another one. And the biggest difference between charities is usually the values, because you could have a church with one set of values and another church with another set of values, and corporately they may look very similar, but it can make a huge difference in terms of what they are going to do from a standards or an ethical point of view. So now I'll jump into the top 20 compliance issues. The number one problem that Canadian charities have in terms of losing their charity status is the failure to file the T3010 registered charity information return. It has to be filed every year, even if you have no activity. It's supposed to be filed within 6 months of the end of the charity's fiscal period. So basically keep in mind that about 600 charities every year lose their charity status just for non-filing this form. For all the other problems that a charity can have, about 30 charities will be losing their charitable status, like for abusive receipting or things of that sort. So by far the biggest reason a charity loses its status is because it fails to file this T3010. Although you're supposed to file it within 6 months, if you're late, like a month or two late, it's not the end of the world. But if you're more than about 6 or 8 months late, you will be deregistered. The form is usually mailed to the charity, but you can also get it online, and if you want to look at the information, you can go to also charityfocus.ca and you can see the information that appears on the T3010. Why do you file the T3010? Well, it's legally required. It is the only sort of uniform way to compare Canadian charities. So whereas financial statements could be prepared in all sorts of different ways, this is trying to have some uniformity. It, if it's done right, should be viewed as an advertisement for the charity. And this is the main, how should I say, transparency piece for a charity. It's the thing that every charity has to put up. It's the minimum you can do. And obviously, as most charities have worked out, it isn't enough. Just doing the T3010 is not going to tell all your stakeholders enough. So you have websites, annual reports, newsletters, things like that, but those aren't legally required. The T3010 is, so it's a very important form. And of course, the consequences for failing to file are quite significant. Not only will you lose your charitable status, which means you won't be able to issue receipts, you'll lose the benefits of being a registered charity. There's a revocation tax that you may have to pay if you aren't re-registered within a year, and in some cases you may not be able to re-register for various reasons. So there's many consequences for failing to file, and it's the number one reason why charities lose their charitable status. Now, the second thing I want to point out is increasingly there has been scrutiny of not just the filing issue, but that it's important that you file the T3010 accurately. So that means use the correct form. If you use an incorrect form, they probably will just reject it and send it back to you. It needs to be accurate, and it has to include, in some cases, schedules, and you have to file also a financial statement. So if you don't fill it in accurately and completely, as of 2012, the CRA has had the power to suspend the charity. So they can basically suspend your receipting privileges. You won't be able to issue receipts if that's the case. There's a lot of help with the T3010 online if you need it. I'll just also point out that one of the top reasons that a charity gets audited is because of something suspicious that's on the T3010. So make sure you do it as well as you possibly can, because it can save you a lot of aggravation. Not to mention that some stakeholders may be looking at the T3010, and if it has incorrect information, that could hurt the organization. These are some of the top problems with the T3010. So using the wrong form, CRA won't be able to accept it, not providing all the information, not providing accurate information, not completing all the schedules, not including the financial statements, and also you have to, for every director, have their date of birth and things like that. And here's just a checklist of some of the forms that may need to be filed with the T3010. Now, the third problem is issuing incorrect official donation receipts. So if you look at the 30 charities that are revoked for cause every year, probably most of them are revoked because they've issued receipts with improper fair market value or some other mistakes or problems with those receipts. So this is a very important thing. This is the main advantage of being a registered charity, is you get to issue these official donation receipts. Now, why do you issue receipts? Well, obviously, for some donors, they can save significant amount on taxes, and depends on, obviously, what they're donating. If it's cash, it's one thing, but appreciated marketable securities, so public shares, in some cases, if they've gone up a lot, they could be having benefits in the 60 to 65% range. And if they don't have enough income in that year to offset, they can carry it forward for another 5 years. And they can basically get rid of up to 75% of their taxable income. So it's a very, very generous tax incentive system we have here in Canada. And so that's why it has unfortunately resulted in some people taking advantage of it, and CRA has been cracking down on it. Keep in mind, a charity doesn't have to issue receipts. And there are times when you will decide you don't want to issue receipts, like, for example, if it's for less than a certain amount, like $20, or you might not want to do it for, if it's a gift in kind and difficult to value, you might decide you just don't want to issue a receipt. Just let donors know what your policies are so that they're not confused or upset after they've given you something. The other thing is that I would say the mantra when it comes to receipting is, if in doubt, don't receipt. Sometimes people seem to be issuing receipts more on the basis of, unless you know it's absolutely improper, issue the receipt. And that is not a good mantra, if you will. So if in doubt, don't receipt. Make sure that if you are going to issue a receipt, that you really are confident that it's appropriate to do it. Now, I'm not going to go through this, but the number one receipting problem is that many charities don't have all the mandatory elements on their receipts, and we have a couple of slides here with those mandatory elements. And then if it's gift in kind, there's some other mandatory elements that need to be there. And probably for most charities, the quickest, easiest way is just go to the CRA website. They have 4 sample receipts, and you can get the template from the CRA right there. And that's the number one reason why charities make mistakes in terms of receipting. Another thing to keep in mind with receipting is that there are a large number of circumstances where, because a person has given you something valuable, it doesn't mean that you can necessarily issue them a receipt. So if you cannot determine the value of the donation or the benefit that they're getting, the advantage they're getting, you won't be able to issue a receipt. Donations of services, so time, labor, skill, to a charity, or loans of loans of a property, or use of a timeshare, or lease of a premises, all those sort of things are considered services. They're not considered property, and therefore you can't issue a receipt with that. Also, if the donation is intended for another organization that's not a registered charity or qualified donee, this is called lending your registration. So where a small nonprofit group that's doing good work in the community, someone wants to donate to them, but they can't get an official donation receipt, so then the person goes to the charity and says, well, can you take the money and give it to us? And we'll talk later about dealing with non-qualified donees, but you can't just use the charity as a conduit to move the money through. Also, generally tuition, except for private religious schools, you're not issuing receipts. For sponsorship or business advertising expenses, you don't issue receipts. Gifts of promises or pledges, you generally are not going to be issuing a receipt. Payment of a basic fee for an event or payment for a program, you won't issue a receipt for that. Membership fees, generally, you can issue a receipt unless the benefits that are received for those membership fees are more than 80% of the value of the payment. Lottery tickets, you wouldn't issue a receipt. Purchases of goods or services from a charity, so if you're an environmental charity selling rain barrels, basically they're buying something from you, you're not going to give them a receipt, it's not a donation. And any time the value that they're getting back, the advantage, is over 80%, you don't issue a receipt. Another thing is, if you're getting money from a qualified donee, which includes various groups, we'll talk more about it later, but say another registered charity, you don't issue them a receipt. Okay, they don't need the receipt, and you're not supposed to issue them a receipt. If you cannot determine the name of the true donor, who is really giving the money, then you should not be issuing a receipt. Also, and this issue's come up now quite a bit, the issue of if you're going to a charity and just saying to the charity, I want you to give money to this other person, then generally you wouldn't be able to give a receipt. But there are times where it may be appropriate to be issuing receipts where there will be certain beneficiaries. So that's just a short sort of view on receipting. According to CRA, 89% of charities do not receipt correctly, so it's a very high number. And obviously there's a difference between having a mistake, like you don't have their website address on your receipt, versus you're issuing $500 million worth of false receipts, okay? So they're not all the same, but vast majority of charities have a problem, and keep in mind 89% aren't doing it correctly, that about 10% are not even issuing receipts. So very high degree of problems with receipts in Canada. Acting outside your legal objects. So very important that charities are paying attention to what are their legal objects. They're usually in letters patent or articles of incorporation or trust deed or something like that. And the basic idea here is you're not allowed to act outside your legal objects. Now, if you have, say, 10 legal objects, they all have to be charitable. You can't have most charitable. Everyone has to be charitable. And basically, if you have 10 objects, you don't have to do all the 10 things that are in your objects, but whatever you do must at least fit within those objects. And if you're doing things that now are outside the objects, because maybe the objects were prepared a long time ago, then you should think about going to get permission from CRA to adjust your objects to make them broader. Okay. And here's just sort of an example of objects, what it looks like. And if you want to change your objects and you write to CRA, keep in mind they're quite slow right now. There's about a 6-month plus backlog. But the main thing is they won't just look at objects. They want to look at objects and a detailed description under each of the objects for what you're planning on doing. So just keep that in mind, that you have to have both the objects and a detailed description. And CRA a few years ago put out a detailed guidance on draft purposes for charitable registration. It talks in detail about how objects are supposed to be drafted, and you might find that is a helpful resource. The fifth legal issue I'm going to raise is what's called gift to non-qualified donees. It's basically if a charity were to be just essentially giving money over to a group that is not a registered charity, then that would be a gift to a non-qualified donee unless certain things are done. So basically, Canadian charities can operate in a number of different ways. One is one registered charity can give money to another registered charity. Okay, the term qualified donee means basically that it's a group that can issue official donation receipts, and there's actually more than charities that can do it. There's about 10 groups that can issue official donation receipts. So one way that a charity can operate is by giving to other registered charities money. Another way is that basically they can carry on their own charitable activities through either using their own employees and volunteers, which is probably the most common way that charities operate. But there's another way that they can carry on their own charitable activities, is by using intermediaries. And intermediaries are groups that are not registered charities. They're not qualified donees. These are groups like nonprofits in Canada, or groups that might be outside of Canada, dealing with all sorts of different issues. So basically, charities need to have direction and control over the funds and resources if they're working with non-qualified donees. And so here, just in terms of a diagram, on the top is your Canadian registered charity. If you want to make gifts to qualified donees, there's a list of them, and you can do that. On the other hand, on the right, you can see that if you want to do your own activities, you can either do them through employees or volunteers, or having an intermediary do the work. And sometimes it's called a structured arrangement, where you have a number of different things, including a written agreement covering the relationship. So basically, just to make sure that it's clear what a qualified donee is, these are groups that can issue official donation receipts for income tax purposes. And a non-qualified donee is, the vast majority of groups around the world who cannot issue official donation receipts under the Income Tax Act. So here's a list of the qualified donees. You've got registered charities, you've got registered Canadian amateur athletic associations, you've got listed housing corporations for low-cost housing for the aged, listed Canadian municipalities. Now there's a list of all these Canadian municipalities, and they're considered qualified donees. This group here are listed municipal or public body performing a function of government in Canada. Most of these are Aboriginal bands, and so there's a list of those that charities can make a gift to. So in other words, just write out a check if they want, without having to maintain direction and control. Also, and some people are surprised by this, there are about 600 foreign universities that typically have Canadian students studying there and that have gotten onto this list. And so basically, if you want to make a donation to a group that is one of these prescribed foreign universities, you can make it and you would get the same tax benefit as if you gave to a Canadian university. So it's a very good thing for fundraising by those foreign universities. It also means a Canadian charity can easily transfer money to one of these foreign universities. Then also there's a category, this listed charitable organizations outside of Canada, to which Her Majesty and the Right of Canada has made a gift. Unfortunately, there's only a couple that are on that list at the moment. And then you've got Canada, the provinces, and also the United Nations and its agencies. So those are all the different qualified donees. Very easy to move money from one charity to a qualified donee. However, if it's not a qualified donee, then you need to have proper direction and control. So obviously the vast majority of groups around the world are not qualified donees. You've got foreign charities, you've got Canadian non-profits that don't have charitable status, you've got businesses, celebrities, all these different groups that are not considered to be qualified donees. And if you want to work with those people, then You have to maintain direction and control. What you cannot do is be a conduit. So basically, let's have the money go to a charity so we can issue an official donation receipt, and then we dump the money onto a non-qualified donee. That would be a conduit, and there can be significant penalties for doing that. So why do you want to deal with non-qualified donees? If foreign activities-wise, it's easy because there are very few prescribed universities or other qualified donees outside of Canada. But even in terms of Canada, often the best organization to implement a charitable project may be a non-profit that's non-charity or a business and not another registered charity. So it's basically the same rules that apply for Canadian charity wanting to work with groups inside and outside of Canada that are not qualified donees. There's two CRA guidances. One deals with activities outside of Canada, and one deals with using an intermediary within Canada, and they're basically very similar. And in one slide, this is what you need to do if you're working with a non-qualified donee. You have to have due diligence on that intermediary to make sure that they're appropriate. There needs to be a written agreement that has certain content in it. Perhaps most importantly, there needs to be a detailed description of the activities that you're going to conduct. Why are you giving this group $100,000 to do the activity? It needs to be set out in some detail. There should be a separate activity and funds. So it's not that you're just giving it to this non-qualified donee so that they can do their stuff. They should be carrying out your charitable activities. There should be monitoring and supervision. If there are going to be changes, there should be ongoing instructions, and if the project is going to be changed from one city to another, there should be approval by the charity of that sort of a change. If it's large amounts of money, there should be periodic transfers, so you don't just send $1 million up front. You send it in various periodic payments. And then, as with everything else, you need to make sure that you have books and records showing the above. Now, I'll just mention one other thing. CRA has a checklist on terrorism, which was released in April of 2009. And basically, it's quite short, worth reading, but it essentially talks about the importance both within Canada and outside of Canada of making sure that the resources of a charity are not used inappropriately. This has come up in a number of instances where there have been concerns of Canadian charities operating both within Canada and outside, supporting things that are inappropriate. Now, the sixth point I'm going to make is fundraising. There has been a huge amount of interest in fundraising. Fundraising brings in about $13 to $15 billion a year for Canadian charities, which is a lot of money. On the other hand, keep in mind the charity sector has about $220 billion in revenue. So fundraising is actually only a small part of what is brought into the charity sector. That being said, because it involves a lot of individuals, people who are making the donations, people are more interested in how their $20 donation goes than they are necessarily perhaps in the government giving $1 million to some group. CRA has put out a guidance on fundraising, and basically the initial consultation draft was in 2008. They put it out in 2009, and they revised it in 2012. And now CRA is actually getting rid of charities, they have been for a few years, that are non-compliant with their fundraising guidance. This is an overview of the fundraising guidance and the different aspects that it has. I'll just point out, even if your charity doesn't fundraise, some of these pieces in the fundraising guidance, like Appendix B, allocating fundraising expenditure, and Appendix C, best practices, could still be relevant to your organization. And so, in summary, fundraising is acceptable provided that it's not this sort of unacceptable fundraising. So, you know, fundraising can't become a purpose of the charity where that's all it does. This notion is a little bit confusing because sometimes, like a hospital foundation, well, it fundraises, but really the hospital foundation's real purpose is not to fundraise, it's actually to hand the money over to the hospital. So, but if you had a group that was taking in $1 million and spending $950,000 on fundraising, and they were doing this every year, then it would be argued that really the purpose of the charity is to fundraise. Providing more than an incidental private benefit. So essentially, you're allowed to have a private benefit, but it needs to be necessary, reasonable, or proportionate in relation to the resulting public benefit. So if you're paying some fundraiser, $1 million, when you can hire someone for $100,000 to do the same job, that would be a problem. If it's illegal or contrary to public policy, that would be a problem as well. If it's deceptive, that is a big concern. And also, unrelated businesses are a concern as well. In terms of a summary, what are the things that CRA is going to be looking to? They're going to look at the resources devoted to fundraising relative to resources devoted to charitable programming. They're going to look for fundraising without an identifiable use or need for the proceeds. So if you have $100 million in your foundation and you're aggressively fundraising and you're only spending 3.5% every year, they would question why you need to be fundraising in that case. The charity's fundraising expenses to fundraising revenue ratio. This has been downplayed a bit over the last few years, but basically, and I'll talk about a little bit more, what does it cost to raise money for the charity as part of fundraising? Is it less than 35 cents to raise $1? Those sort of issues. Inappropriate purchasing or staffing practices is also a concern. So if you're purchasing, for example, fundraising merchandise at a very high cost, and it's, then that wouldn't be appropriate. Paying more than fair market value for fundraising merchandise or services, as well as sole source or not arm's length contracts with suppliers. So they're not actually saying that you can't have a sole source contract or you can't do a not arm's length contract, but they will be very concerned that it may be that the charity is not getting fair market value or better in terms of the services or supplies that they're getting. Anytime most of the gross revenue goes to non-charitable parties, that'll be a concern. CRA is concerned about commission-based fundraiser remuneration, or basically payments to fundraisers based on the amount or number of donations. So essentially, now keep in mind that many fundraising organizations, such as the Association of Fundraising Professionals, they prohibit commission-based fundraising. CRA doesn't prohibit it, but they say that they're concerned if it would result in too much remuneration. Some of the other things that are of concern are misrepresentations in fundraising solicitation. And this is a big thing because it's important that charities do disclose how they're fundraising, what sort of costs they have associated with it, and what sort of practices are they using. So are they all volunteers that are working for you? Are they employees? One should be upfront about these things. Also, anytime a fundraising initiative is not well documented, that gets back to books and records, and that would be a concern. The other thing is there are a few things that CRA will use sort of to mitigate. One of them is the size of a charity. So a small charity, the expectation is that it may be harder for them in some cases to fundraise. Causes with limited appeal. So this means, for example, if you're trying to raise money for improving, services for, ex-cons or something like that, it's not going to have as many people who'd be interested in donating to that, so it would be expected that the costs may be higher. Donor development programs, things like bequest programs where you invest now and it maybe pays off in 10 or 20 years, those they understand will have higher costs. And also gaming activities in many cases can have very high costs. CRA is okay with that. However, they just say you have to comply with the provincial rules, and as long as you're complying with the provincial rules, then that's okay. This is the fundraising ratio. So it's the ratio of cost to revenue over one fiscal period. So basically you take all of your fundraising revenue and you have all of your fundraising expenses, and what is the ratio? If it's under 35%, so under 35 cents to raise $1, then generally CRA is not going to be concerned with that number. If it's over 35% and under 70%, they're going to examine it, they'll look at a number of years, and they'll expect you to have some sort of plan as to how you can try and minimize the fundraising costs and things like that. And if it's over 70%, they will have a problem with it. Keep in mind that there are all sorts of things that can happen that can result in 1 year in you having much higher fundraising costs versus revenue. For example, if a donor gives you a $1 million donation and you're a $2 million charity and you get the $1 million donation December 20th, it makes a big difference as opposed to January 10th. So just the timing issues can make a huge difference, and CRA would look at that when they're looking at over a number of years. Misrepresentations is a big issue. Basically, I mean, it's obviously common sense. You should be not misrepresenting what you're doing, but unfortunately, the concern is that some charities are not completely upfront about certain things. So, for example, the geographic area in which a charity operates, the amount or type of work it undertakes. So some charities, they call themselves a national charity, and they say they're delivering services in every province, but when you actually drill down, they're really only maybe based in Toronto, and they're only really helping people in Toronto. This is particular concern for small and rural charities who feel that you know, if groups are not actually providing services in their community, then they should be upfront about that. CRA is also concerned about claims about the percentage of funds raised will go to charitable work. So groups that say, you know, 100% of your donation will go to charitable work, it may even be technically true, but it is viewed as often misleading, and it also makes other charities who maybe cannot make such claims because they have to pay for, say, some costs. It may have a sort of a negative inference, and the only way that charities can do this is by taking other money or having others basically subsidize the fundraising costs. So it doesn't even mean the fundraising costs will be low. They could be very high. But so anyway, just be careful when making claims like that. One of the other concerns is disclosure, and you know, disclosure basically of fundraising costs, revenues, practices, so that the public is aware of what is going on and they're not deceived or misled. And to be meaningful, disclosure must be accurate, accessible, and timely. So obviously accurate. If it's hidden on your website 10 pages in, then it's not really accessible. And if it's a pie chart from 10 years ago when you had a great fundraising year, then it's not up to date and timely. So basically, that's on the fundraising stuff. You know, a lot of media scrutiny of fundraising, and important that one tries to make sure your fundraising practices are in accordance with CRA's guidance on fundraising. Now, charity gifting tax shelters, many people have never heard of these things, and that's not a bad thing. Basically, these are schemes where, for example, a person will put in $10,000 and they'll end up getting a $100,000 receipt. It's based on valuation issues where basically, for example, someone will buy pharmaceuticals in India for, say, $50,000, but they'll value them at $100 million, because if you bought, you know, 2 pills in Toronto, that's what it would cost, you know, but you're not buying 2 pills in Toronto, you're buying thousands of pills in India, and anyway, these things have been in the courts, and they don't work, and about $6.3 billion in receipts have been issued as part of these gifting tax shelters over the last 10 years. So that's a lot of money. 190,000 Canadians are being audited on these things. If it sounds too good to be true, it is, and stay away from them, okay? CRA has been putting out alerts, well, going back to the 1990s on these things, and quite a few charities, maybe about 50 altogether, have lost their charitable status because of involvement with these types of schemes. There's also been many, many significant penalties leveled against charities and their directors for involvement in these schemes. Now, I'm going to talk about the 8th issue, which is employment issues. And this is actually for charities or nonprofits. It's not that different. And also for for-profit businesses. So is someone an employee versus an independent contractor? If you have a person who is an employee, then you would withhold the source deductions and remit them. But if you call someone an independent contractor and they're really an employee, the charity can be on the hook, and the directors too, for the fact that they didn't withhold and remit the source deduction. So it's very important to make sure that you get it right, and CRA has a guidance on this. The other thing is have proper employment agreements, so that if, you know, it is necessary to terminate, one at least knows what the situation is. There's also a concern sometimes about excessive compensation, where, for example, an executive might be paid $1 million or $2 million in a year. But obviously, in reality, the biggest problem within the charity sector is the opposite. You have a lot of people who are not being paid very much, and that doesn't get as much attention. But just so you know, the excessive compensation issue is one that usually makes it into the media. Now, it's very important when a charity does work that it's obviously charitable and appropriate, but it's also important that they have the books and records to demonstrate that in fact they have done the appropriate work. So in other words, it's not good enough to just do good things. You need to be able to show later that you have. CRA expects that you'll keep adequate books and records in Canada, preferably in either English or French. CRA must be able to verify revenue, also that resources are spent on charitable programs, and that the charity's purposes and activities continue to be charitable. Why do we need to have adequate books and records? Well, essentially, it's very hard to understand how you can run an organization efficiently, effectively within the law if you don't have good books and records. You know, where are your expenses going? Where is your revenue coming from? Without good books and records, you wouldn't know that. Obviously, you needed to issue official donation receipts. It can help you with decision-making around, you know, the effectiveness of particular programs and things like that. Also, in terms of filling out the T3010, it'll make your life easier. It'll have information on current and past financial position of the charity. And keep in mind that in many cases, CRA is not the most demanding stakeholder. They require that you basically every year report with your T3010 on the activities of your charity. But many funders, for example, might require quarterly reports and things like that with all sorts of other requirements. So you have to keep books and records essentially to the level of your most demanding stakeholder. And here are just some examples of what would be considered books and records. Now, the 10th issue is failing to meet the disbursement quota. The disbursement quota is the amount that a registered charity has to spend each year on charitable activities or make gifts to qualified donees. The main thing I would make a point about is that the 2010 budget removed most of the disbursement quota requirement, which is if you issued, for example, $1 million in receipts, then the following year you would have to spend $800,000. It was the 80% rule. And I still run into people who think that it still exists, and it doesn't anymore. So right now, there's a much lower disbursement quota, which I'll talk about, but just keep in mind that you don't have to spend 80%. Essentially now how it works is that they look at what property a charity has that is not used in the charitable or administrative activities of the charity. And so they look at that property and essentially, let's say you have some investments, $1 million in investments, then you would basically have to spend 3.5% of that amount, okay? So you would look at endowments, investments, reserve funds, buildings owned by the charity, not used by the charity for charitable or administrative purposes, and it would be 3.5%. So for most charities, they're spending way more than this amount. And this is really a low amount to expect. So it's not that hard to meet. So I just wanted to make sure that people understood that the 80% rule has been removed. Now, political activities. There have been some changes in tone relating to political activities recently. We have a new government, and but really nothing has really changed in terms of Canadian charities are allowed to conduct political activities as long as they're nonpartisan, connected to their objects, and are not spending generally more than 10% of their resources. Okay, you're not allowed to have political purposes as a charity, political objects, but you can have political activities. You can't be doing illegal or partisan political activities, and when you do political activities, it has to be related to your object. So if you're an environmental charity, you can do stuff relating to the environment. If you're a charity that is concerned with women's health, then you can do political activities related to women's health, okay? And then generally speaking, you're not supposed to spend more than 10% of your resources, which is more than just money. It's people and other things. You're not supposed to spend more than 10% on political activities. And as long as you're following that, and there's a guidance from CRA, CPS 22, then you should be fine. CRA is winding up that political activities audit program that the Harper government had started, and after all that, essentially about 5 charities have been slated by CRA to lose their charitable status. Essentially, a political activity can be a prohibited activity if it's illegal or partisan. It could be allowable, and then it fits in the 10%, And then there's all sorts of activities that CRA considers charitable that most people would consider to be actually they would consider it to be political. So, for example, communicating with an elected representative or public official, most people would think, hey, that's political, but CRA considers that charitable. So just keep that in mind. Now, unrelated business activities. So basically, charities are allowed to do business activities, and in fact, they do a lot of business activities, and they bring in a lot of money from business activities. And basically, what charities are not allowed to do is unrelated business activities. So what does this all mean? So basically, charitable organizations and public foundations can do this related business activity, but private foundations, they're actually not allowed to engage in any business activity. So what is a business activity? Basically, it's a commercial activity where you're deriving revenue, providing goods and services, and there's an intention to earn a profit. And it has to be done on a continuous basis. Otherwise, it would be considered something other than a business activity. Now, although charities, a lot of them do it, and they make a lot of money on it, there are a number of concerns because, remember, charities don't have to pay taxes on their surpluses at the end of the year. So what does that mean? That means that if every business in Canada was run in a charity, no businesses would pay taxes. So that's not necessarily an ideal situation. There's a concern by some small businesses especially that it's unfair that charities are competing with them. So basically, and other countries have other systems where they allow charities to do more, but they tax it. How it works here in Canada is a charity can have a related business activity. So I'll give an example, like a hospital parking lot, which can bring in, say, $20 million. And let's say the cost of running it was $2 million a year. That means they have $18 million in profit, but they don't have to pay any taxes on the $18 million. So it actually, for charities that do business activities, it can be a very positive thing. So there's two types of related business activities that a charity can conduct. I'll take number 2 first because it's the easiest. Essentially, businesses that are run substantially by volunteers. For example, a coffee shop run by volunteers, maybe in a hospital or something like that. So if it's substantially more than 90% a volunteer-run initiative, then the charity can do any business activity it wants if it can organize it that way. Then the main one actually is number 1, where to be a related business, it has to be linked to a charity's purposes and subordinate to that purpose. So what does linked mean? Linked means, in the case of that hospital parking lot, that it's next to the hospital. If you were to have a hospital parking lot that's on the other side of the city, that would not be linked to the hospital, and therefore it would not be appropriate. It has to be subordinate. So, you know, the example with the hospital parking lot, the hospital might have a $500 million budget. The parking lot is $20 million. So it is subordinate. It's a small part of the whole thing. But if you had a $20 million parking lot and a $500,000 clinic, then it wouldn't be subordinate in that case. So there's lots of opportunities for charities to carry out related businesses, but they must make sure that, in fact, it'll be considered a related business by CRA. CRA has a guidance, CPS 019, what is a related business. They also have another guidance which is quite good on community economic development. Keep in mind that if you run an unrelated business within a charity, there can be significant penalties. And I guess one other point I would just make about related businesses is that you can generally have a lot of flexibility because in some cases you can also, if it's not going to be a related business, you can put it in a for-profit company and the charity can own it. It'll have to pay taxes, but they can wipe out 75% of the taxes by just donating the profits to the charity. So in fact, charities actually can do a huge amount of business activities. Now, transactions with directors. Ontario has, you could say, stricter rules than maybe other provinces because we have the public guardian and trustee of the Attorney General's office that says that directors are not allowed to be compensated as directors, but they're also not, generally speaking, allowed to be compensated as employees or contractors or something else. Now, In other provinces, it's debatable what the story is. I think the Public Guardian in Ontario would say that the rules pretty much across Canada are actually the same, but there isn't maybe the enforcement of it. But essentially on the CRA side, CRA doesn't necessarily have a problem with, for example, a director being a contractor, but they will scrutinize salaries, loans to directors, investments in companies of directors, transactions with businesses owned by directors. They will be very concerned that it may not be a good deal for the charity, and there can be all sorts of penalties and problems as a result. So the general governance best practice is it's best for all the directors to not be compensated in any way, shape, or form except for reimbursement of reasonable out-of-pocket expenses. So another thing is 800 charities every year are audited, and if you're being audited, very important that you handle the audit correctly. Your chances of being audited are about 1%. CRA audits about 1% of charities a year. They have an obligation to audit charities, and you as a charity have an obligation to assist them with that audit. And here I'm just going to be talking about a CRA charity audit, not other types of audits like for EI, CPP, and GST and things like that. So out of the 800 charities that are audited, about 30 every year will be revoked for cause. So it's only 4%. And if you think about it, you know, some of the charities are revoking for cause. There's a huge amount of media publicity and other things. So in fact, 95% of charities or 96% will come out of an audit with either a letter from CRA or a compliance agreement and not revocation. So the 800 charities that are audited every year, about 600 are field audits and 200 are office audits where CRA just asks some questions and essentially has the charity send them some information. Okay. How are charities picked for audit? There's a small amount, I would say, that's random selection. It could be because a complaint comes in about the charity from the public. However, I can tell you CRA gets lots of complaints, and that is not by any means a reason that they necessarily will audit a charity, but it could be. A red flag from a T3010 filing is increasingly the situation. If you're doing a lot of issuing receipts and fundraising activities, but you put down no costs for fundraising, then that could be a red flag, and there's a whole bunch of things like that with the T3010 that you could get in trouble with. If you're involved with an abusive tax shelter or charity receipting fraud, it's almost guaranteed that you'll be audited. The audits also happen because of follow-up on previous audits or some sort of compliance agreement that you might have had previously. And then sometimes CRA does a review of a particular segment of the charitable sector or a particular type of area. So foreign activities at times have gotten attention. Political activities over the last 3 years have gotten attention. Sometimes they'll be looking at church groups. Sometimes they'll be looking at groups that do other types of activities. And basically, CRA is looking for financial information, but then also other things relating to how the organization operates in charitable activities. The approach that CRA takes, they call it education first. So they're not trying to go there to revoke your charity. Instead, they want to just make sure that if there are some things that are not appropriate, that you try to change it and do things differently. And here's some statistics that came from a small and rural charity report. I mentioned before 89% of charities had incomplete or incorrect official receipts. So that's a huge percentage. 72% of charities didn't do their T3010 correctly. 71% had insufficient books and records. 16% had made gifts to non-qualified donees, so that's like foreign charities or Canadian nonprofits without necessary direction and control. And 13% carried out non-charitable activities, including excessive amounts of resources being devoted to fundraising, political, or social activities. So there is quite a bit of non-compliance. CRA doesn't expect perfection, but like I said, there's a difference between some minor technical non-compliance and the extreme abuse of charities that sometimes takes place. Here's just a few tips for handling an audit properly. If you're contacted by CRA, don't put off responding, respond quickly. One of the most important things is be cooperative and polite. In many cases, it's not like It's the highlight of an auditor's career to be going into a charity to audit it. Many of these auditors maybe would prefer to go into, Fortune 500 companies that are doing, complicated tax schemes or whatever the case may be. So the other thing is that if, for example, you're usually given a few weeks before the audit's going to take place, make sure that you try to pull your records together, make them up to date, and things like that. Don't backdate things, but if, for example, you notice that you haven't been doing something correctly, then I would say start doing it correctly. It's you'll probably be treated better by CRA if you're showing some not only cooperation but willingness to change. You don't need to have a lawyer, but for some people from a mental health point of view, maybe it's a good idea to have a lawyer involved. Certainly if you've been involved with some tricky or problematic stuff, it might be worthwhile to have a lawyer involved, but in most cases the lawyer can just be kept in the background giving some informal advice or formal advice with respect to how to handle the audit. Make sure that if there are questions asked that you only answer them truthfully, and only if you know the answer. If you don't know the answer, tell them you'll get back to them on it. The expectation isn't that you're going to know everything. In terms of providing documents, don't dump documents on CRA. If you give them 20 boxes of stuff, most of which they didn't ask for, they may even read everything, and it could hurt you. Give them what they're asking for. And remember, solicitor-client privilege. If you've got documents where a lawyer has provided you with advice, you don't have to provide that. Copying of documents, provide copies, keep the originals, because sometimes your CRA may misplace the documents or it may take them a while to look at them. So you want to make sure, ideally, you have your copies. And then if they give you some preliminary sort of findings or there's some discussion, take notes. They're not always right, in the spur of the moment that they're looking at something, but in some cases, most cases they are right. And certainly it's worth paying attention. In some cases, it can take CRA a year or two to send that final letter saying, there's a few things that need to be adjusted, and if you can fix it because of you're paying attention with the preliminary discussions, then that might be a good thing. Another thing that's quite important, number 15, is that when you are going to make certain changes, that you let CRA know. If you're going to change your name or address and things like that, it's very important to let CRA know. Another thing is that certain types of requests require CRA approval. For example, if you want to change your fiscal period. So very important that you put in those requests. Just a simple thing, if you don't tell them your updated address, all the notices they send to you will not probably arrive. So very important to provide up-to-date information. Now, in terms of corporate changes, just want to point out that in a number of provinces, there have been and are continuing to be significant changes in provincial corporate law. Federally, the new Canada Not-for-Profit Corporations Act came in basically in 2011. And for groups in Ontario and BC and Alberta, there's been lots of changes. So for example, it's very important to know what is your nonprofit, your charity set up under. Is it under the, for example, the old Canada Corporations Act? There are 2,000 charities that are still under the old CCA. They're probably going to get dissolved pretty quickly, and it's really important that those groups move over to the new Canada Not-for-Profit Corporations Act. So if you're under the old Canada Corporations Act, very important that you move under the CNCA. Ontario, the Ontario Corporations Act is going to be replaced by what's called ONCA, but it's been delayed by another 2 years. And then, you could be a trust, an unincorporated association, etc. But make sure you don't get dissolved, because if you get dissolved, then you don't exist. And CRA takes a position that if you don't exist, you shouldn't be a charity. For many organizations, if they're getting set up, if you're setting up a new charity today, I would generally say set it up under the new Canada Not-for-Profit Corporations Act. It's a federal act. It works really well. The big concern right now is these 2,000 charities that haven't moved over to the CNCA. That'll probably be dissolved in the next few months, and then eventually they'll lose their charitable status as well. As I've mentioned, ONCA, the Ontario Act, has been delayed, so we won't be probably seeing anything there over the next, until maybe at least 2 years from now. For groups in Ontario, they can do nothing and wait for ONCA to come into force. They can make certain changes to clean up certain things under the OCA and then later move over to ONCA. Or what they can do is, and we've been helping a number of groups do this, is basically move from Ontario to federal jurisdiction. And this is particularly good if you have a national organization, you have people from different provinces, and if you operate internationally, for example, it might be simpler in a way to be a CNCA corporation than, for example, a Manitoba corporation. So that's just in terms of make sure however you're set up, that you don't get dissolved, because if you do, then you won't be able to be a charity. And then another top sort of issue that I would just highlight is that increasingly many donors are giving money with restrictions attached, which creates sometimes quite significant problems. Keep in mind that if you accept a gift with a restriction, then it's important that the charity has to comply with that restriction. The only way out of it is basically if you get a CRA court order, or if there's some ability within the gift agreement to make a change. For example, with the consent of the donor, you can change it, or if the board decides to change it, it'll be allowed. But other than that, you can't really change a gift agreement and a restriction. There were 2 cases recently out in BC where people, the donors and the charities, both agreed that restrictions should be changed, but there wasn't a mechanism within the gift agreement to make the change, and the court was not prepared to listen to their arguments. So the point really is very important to make sure that you carefully deal with restricted gifts. The biggest myth in this area is that if you have a restricted gift, and if there is no amendment clause, as long as the charity and the donor agree, then it's okay to make changes, and that's not correct. So restrictions, so in terms of restricted and unrestricted gifts, there's unrestricted gifts, so you can spend it according to your objects. There's precatory or non-binding restrictions, so that's where someone just says, I'd like it, but I'm not expecting that you necessarily will. There can be internally restricted gifts, which is basically a gift that comes in and the board decides to restrict it in some way. There can be conditional gifts, so condition precedent, condition subsequent, where there can be restrictions like that. There can also be types of restrictions. So for example, it can be restricted as to the subject matter of the expenditure. So it only can be used to help poor people in Vancouver, as an example. Or it can be restricted as to the timing of the expenditures. So it could say you have to keep it in perpetuity and only keep the capital in perpetuity and only spend the income, or spend 20% of the funds per year. There's various types of restrictions, but the one is on the area and the other one is on the timing and when the money will be spent. And then, it's a whole area, obviously, in terms of restrictions, but I think many charities don't realize that they are themselves, in many cases, encouraging people to put restrictions in, which may actually not be in the best interest of the charity. As well, donors, they sometimes are asking for restrictions, and they don't also fully understand that maybe in 10 years from now, it might be that even they think that the money should be spent somewhere else. So it's very important to maintain an ability to make changes. As well, third parties raising funds for a charity. So for example, if someone hosts an event and they're raising money and they say that it's going to be used to pay for a particular scholarship program or something, then the charity, when it gets the money, has to use it in that way. So keep in mind another little thing, which is if a donor retains too much control by placing stringent restrictions and has ongoing involvement with a gift, it could mean that it's not actually going to be considered a gift. And it might be that you shouldn't be issuing a tax receipt because they haven't really made a full, complete transfer of the asset over to the charity. So there's many challenges with restricted gifts. Donors are well-intentioned, but they don't know often what is in the best interest of the organization. What's in the best interest of the organization can change over time, and donor interests change over time as well. It can undermine the mission, as funds may not be available for the most important needs. If a large proportion of funds are restricted, it can make financial management and planning very difficult. Also, having a lot of restricted long-term gifts can make it look like you're a very wealthy organization when in fact you have access to very little funds, so it can undermine fundraising. So preventing problems with restrictions, you can refuse a restriction, but you may lose the gift. You can suggest restrictions to the donor that are broad and compatible with the areas of greatest need. You can negotiate a broader restriction with the donor. You can accept a restriction but realize that it can diminish significantly the real value of a gift. Ensure that there's clear communication. Include the necessary caveats and provisions in a restriction so it allows you to, for example, be able to make changes. Essentially, you want to try and maintain as much flexibility as possible because the world is constantly changing. And have an updated and appropriate gift acceptance policy which takes this stuff into account. What I've seen, unfortunately, is that in some cases, charities that have a lot of restricted gifts, when they are in a financial crunch, they end up doing things like borrowing from the restricted gifts, and this is highly inappropriate and can result in huge problems for the charity. So very important that you manage the whole issue of restricted gifts. And then when you're doing fundraising and you're asking people to give you money for a very particular cause, like, oh, we're going to raise money for a new wing on a hospital, it's what's called special purpose fundraising. Keep in mind you can only use those funds for that purpose. You should always have a caveat that in the event circumstances change or it's oversubscribed or whatever, or the hospital is going to be demolished and you don't need then a new wing because there's a new hospital going to be built, that you should have some ability to make adjustments. And those sort of caveats should be included in all the sort of fundraising solicitations you're making. Otherwise, you're going to be in a situation where you may have to go to court. They may not be too interested in listening to your arguments as to why you should have a CRA order. So keep records of fundraising campaigns and the purpose of them and any caveats that you have as to how the money can be spent. Then I'm getting to the end here. Just want to point out something. Increasingly, voluntary standards are very much in vogue, and they can be very helpful, in fact, for organizations to operate at a higher level, do a better job of the work that they're doing. But understand any voluntary standards before adopting them. Consider carefully whether you should adopt the standards, and realize once you've said you're going to adopt them to the public, they're no longer voluntary. So important to just pay close attention to that. Sometimes I see the marketing departments think it's a great idea to subscribe to some standard, but you will then have to make sure that your organization complies with the 100 or so requirements or whatever it is that the standard imports. Okay, so keep that in mind. Another thing, just a small thing, we talked about abusive charity gifting tax schemes, but there's a much simpler type of charity receipting problem, which is fraudulent tax receipts. And basically that's when some tax preparer prepares hundreds of tax receipts, and there's no donation usually to a charity. They basically, the preparer would take a percentage, say 10%, and one preparer, for example, issued like $50 million in these of these receipts, and there are lots of cases in the Tax Court of Canada dealing with them right now. Make sure if you hear of people issuing receipts in the name of your charity that are inappropriate, let CRA know, let the police know, that sort of thing. Keep tight control over your receipts and your systems and your computers that can issue receipts. Now, there are other legal concerns, but I've just listed a few here on the next couple slides. Getting into big funding agreements and leases can be a concern if you're not careful, because it may have obligations that you may not realize. There's been a concern over the last few decades with charities abusing children and beneficiaries and things like that, and that can be a big problem. Criminal gangs, money laundering, and terrorism, obviously you want to avoid that. Fraud against charities, misuse of charitable assets, that's a big problem. It comes up occasionally when it's in the media, but important that charities have good internal controls. I mentioned the issue of respecting donor restrictions and breach of trust, and that is a very big potential concern. And then safety of staff and volunteers. Terrible incident happened recently where a number of Canadian volunteers in Burkina Faso were killed, and so one must pay close attention as much as possible to training and planning and things like that when one is in areas where there could be potentially violence. There's concerns around undue private benefits, and also this concept of an ineligible beneficiary, sorry, an ineligible individual, which is a person who's been abusing charities that then should not be controlling another charity. So yeah, anyway, this is basically the presentation, and I'm happy to answer questions.
Wonderful. I want to thank you, Mark. That was a very info-packed presentation today, and I know that we've gone a little bit over time, so those of you that need to leave today's session, we will be sending out the recording tomorrow with the question period in case you need to go. So Mark, I think I'm going to ask if we keep it to just 3 or 4 questions today. We have flagged some for you in the chat box. I don't know if you can see them or if you'd...
Yeah, I can see that.
Okay, so if you'd like to pick out a couple that you think would be good to cover, feel free to do so.
I might have the wrong chat box open, so why don't you tell me what ones you want?
Sure. First of all, we had a couple of people ask about how to verify if they're registered federally or provincially.
Right. So that's a good question. In Ontario, for example, there is no publicly accessible list of organizations. I managed to get one from the Ontario government through Freedom of Information, and I put it up. Federally, it's easy. You can do a quick search at Industry Canada's website, and a number of the provinces also have publicly accessible systems. So you'd have to look and see. And sometimes one can also do a name search just to see what is on the different provinces' systems if one really can't find which jurisdiction is the entity under. And in some cases, people think they're incorporated, but they're not. They might be an unincorporated association. So very important to understand how one is structured. Otherwise, the answers you're getting and the things that you're doing may not be appropriate. Okay.
Wonderful. Now, with regards to having backup data on gifting and tax receipts, how long does this need to be kept on file before it's purged?
Well, according to CRA, when it comes to general records, it's usually 6+ years, so you keep it for about 7 years. Now, when it comes to receipts, they only require you to keep it for essentially 2 years after the tax year that they would be used. Okay, but I would suggest for clients generally, because of the possibilities of fraud and other things, that they keep them for as long as they keep the other records. So 6 or 7 years, even though it's not legally required.
Great. And does that need to be kept in hard copy form, or can it be electronic?
It can definitely be electronic, but the key thing is if it's electronic, it needs to be printable if requested by CRA. So don't keep it in an electronic format, for example, that's proprietary, and then you no longer use the program and you can't access it. So as long as it is printable and accessible, it can be kept electronically. For small charities, I generally suggest they're better off just to, if it's like 50 receipts a year, just print it and have it, and that's good enough. But if you're doing tens of thousands of receipts, then it's actually in many ways a lot easier just to have it stored electronically.
Wonderful. Now let's move into the fundraising piece. We had some questions about defining commission-based fundraising. Could you talk a little bit about that?
Sure. So a commission-based fundraising would be, for example, if you go to a telemarketing company and you say to them, you make calls for us and you get 50% of the money that comes in, or 90% of the money that comes in. That would be a commission-based fundraising system.
Wonderful. And another question that came up was an organization that had a foundation request a receipt for their gift, and they're wondering, is it actually illegal to issue that receipt?
Yeah, you're not supposed to issue a receipt. Now, when you say foundation, I'm assuming you mean a Canadian registered charity that's a foundation. If it was, for example, a Swiss foundation, then it is possible to issue a receipt to them. But if it's a foundation in Canada that's not a registered charity, so it's just like some company has a little foundation on the side, then it would be possible to issue a receipt. But if it's a registered charity, no, you should not be issuing receipts to any qualified donees. So that means also if you get money from the Canadian government, provincial, municipal, any other registered charity, you don't issue a receipt for that money.
Okay, wonderful. And our last question, I think, for today. Before a charity loses its charitable status, for instance, for poor receipting, is there a fine, or is it an outright suspension, or are they just completely shut down immediately? How does that work?
Well, the way I'd put it is that the CRA's policy is education first, and they don't quickly move to get rid of organizations. So in most cases where charities done things that are improper, they probably will just revoke their status. When it's significantly improper and that sort of thing. There can be, in some cases, significant penalties. There have been, for example, a couple cases where $24 million penalties have been put out there or something like that. And there was recently a case in the Supreme Court that validated these type of penalties. But that's for massively inappropriate behavior, like where you're issuing, tens or hundreds of millions of dollars worth of inappropriate receipts, right? But generally speaking, most charities, they just get a letter from CRA on an audit saying, you should fix these things, or they get a compliance agreement. That's what most charities get. And then maybe about 4% are actually revoked for cause, and only a tiny minority of those, there would be something like a penalty that would be imposed upon them. CRA also has intermediate sort of steps that it can do. They can suspend a charity's receiving privileges and things like that. So there are other tools that they have that have been around more recently. But generally speaking, when people get into significant problems with CRA, they're usually quite aware that there's a big problem, that their conduct is problematic. And in many cases, when an organization is going to be revoked for cause, in many cases they've been warned before, and in some cases a number of previous audits. So it's not just sort of a thing that quickly happens where CRA just goes into a charity, a normal sort of charity, and they're making some mistakes and then they get revoked for cause. That would not be the case. As I mentioned, there's a high degree of non-compliance amongst charities, and very few charities are actually being revoked. Okay.
Wonderful. I think that's probably reassuring to most people on the call today. So
absolutely.
I think we'll cap it there. And I just want to thank you, Mark. It was an absolutely full presentation. You packed so much into a short time today, and I know that the folks on the webinar today really appreciated that information as well. We've had some nice comments on Twitter. Thank you for those of you that joined in there. Before we sign off today, I do want to remind you all that we will follow up with you by email tomorrow. You will get the webinar recording and the presentation slides. Mark has also generously provided a checklist that will have more information that you'll receive as well. Also in the email tomorrow, we're going to include a link to a very short survey. It takes about 5 minutes to fill out, and it's really helpful for us to help us refine our webinar content and our delivery. So you'll have an opportunity there to let us know also if there's any topics you'd like to see covered in a future session. So I'd like to thank you all again for joining us today, and I hope that you have a wonderful day today. Thank you.